probate law.
Thank you, Martha. Very nice. How long do I have?
About 10, 15.
Okay.
I'll let you know.
All right, I'll be really quick,
when
man.
I go like this.
Okay, yeah. My name is Justin Stivers. As Marta said, I own the Probate Law Firm. Our office is in Brickell, but we're in about 17 different counties. All we do is probate, so I don't do title, I don't do real estate, I just do probate. I started doing this presentation, Probate 101 for Realtors, because I think I'm seeing a lot of Realtors coming across probate listings, coming across either on the buyer side, on the seller side. Florida being an aging population, chances are at some point in your career, you're going to come across a property where the owner has passed away. And so this presentation, again, I'm going to try to keep it as brief as possible, is not to give you every possible thing you need to know about probate, but I really just want you all to have a working definition, working idea of what probate is, how to locate a probate property, talk a little bit about trust, how you can avoid probate, and some other estate planning techniques as well, and then hopefully if I have time, give you some ideas how to market for probate listings, because at the end of the day, it's all about getting listings. Also, I'm passed around a sign-in sheet. I think you all had a sign-in sheet as well. If you would put your name, and I'll send you all some free information about probate. And then if you drop a business card in here, Raffle off a gift at the end. So, show of hands, who has dealt with probate either on a personal or professional level? Okay, a couple of you. Experience, good, bad, slow, costly? Slow? Okay, yeah, that's usually the response, and it's definitely, I don't want to lie and say it's super quick, but it can go a little bit smoother, and so hopefully some of the things I share with you all today will help you all get the probate to go a little bit quicker. So real quick, just a couple key definitions. Probate is essentially a court process. It involves judges, it involves attorneys, and it takes what a person had when they were alive. Now that they've passed away, the court is going to say who gets what. So anytime you hear the word probate in your world, in the real estate world, basically John Smith owned a piece of property, now he's passed away, his children want to sell the property, they need to go through the probate process for the court to say who the owner of the property is in order to sell it. Decedent, that's another term that we use a fair amount. That's just someone who's passed away, a dead person. Decedent is what we say. Last will and testament. Who knows what a will is? Yes, ma'am?
Mm-hmm.
What is it?
Oh, basically, directing where your money goes when you pass away.
Yeah, money, property, anything that you have. It's a piece of paper that basically says, I, Justin, want my wife to get everything that I own when I pass away. One question I get asked a lot, wills are not real formal. Generally an attorney will do it, but I could basically write on this piece of paper, generally handwrite it, have some witnesses, and then I could give it to Martha. She puts it in her drawer. No one else knows about it. So I get asked a lot is, can you find a will? Or I think my parents had a will, how can I find it? Unfortunately, there's not a will.com where I can go search. Well, there's probably a will.com, but I can't go and find out, if someone had a will. So I get asked that a lot. Are they recorded? Is there like a database? Unfortunately, there is not. Then estate. So an estate is basically, again, John Smith, he owned everything. Now that he's passed away, we refer to everything as his estate. That's a term you're going to use a lot. And then the last one, the personal representative. In Florida, we use the term personal representative. Some states use the word executor. New York uses the word executor. You all, in your world, this is very important because the personal representative is the person who's able to sign the closing documents, sell the property. So you would be working with the personal representative. But the personal representative is, again, named by the court, and it's the person who gets to do everything in the probate case. All right, any questions? I know I'm like rushing through all of that as quick as possible. But, okay, so I gave you all, I just want to give you all, I gave you all 4 handouts. They might be in the back if you don't have them. But does everyone have this first property appraiser printout, 11309 Southwest 200th Street?
Yes.
Okay, so who's the owner of that? Maria Pichardo, and then you see EST after that. So whenever you're looking to find out, I guess really whatever the first thing you all do as realtors, when someone says, hey, I've got this property that my client wants or that they want to sell, you all probably go to the tax roll county property appraiser's website to find out who the owner is. So this is the easiest way to find out if a property is going to go through probate. In this case, Maria Pichardo owned this property. Now next to it, it says EST of, which means estate of. So this property, before her daughter could sell it, had to go through probate. So whenever you're, looking at a potential listing and you see EST after it, stands for estate of, 99% of the time means it's going to have to go through probate. Yeah? Cool? Okay. All right, the next one, just quick example, 1821 Northwest 33rd Street. Everyone see that? Mm-hmm. All right, so we've got, are you just saying yes or you actually have it? Okay. All right, so we've got two owners. You see Jesus Silva, EST of, and then you see Maida Silva. So this one is pretty common that you'll see here in Florida, where you're gonna have two owners. So this is an example where Jesus is the father. Him and his daughter own this property, and without getting into title, they owned it as tenants in common. So Maida, she was the only daughter, there was no will, she was already on title, so she assumed she's going to inherit the property. Her dad, Jesus, passes away. She wants to sell the property. She goes, she gets a realtor, they go through the process, get a buyer, go to closing, title says no, you've got to do a probate. So they basically wasted 4 or 5 months in that process. Then we came, we did the probate for Jesus, got the property 100% in Maida's name so that she could sell the property. So this happens a lot here in Florida, where siblings own a piece of property. Parents and daughters, parents and children own a piece of property. They think they're automatically going to inherit the property, but unless you have some of the estate planning documents like a trust or a deed with joint tenants' right of survivorship, it's going to go through probate. So this was, I think probably rightfully so, Ms. Silva was pretty pissed off at her realtor because they went through this whole process and it didn't, until they got the title, did she realize, and the probate only took about a month, but still, she wasted a lot of time doing that. So if you see two owners, and one of them again has that EST of, probably indicating that you're going to go through probate. Questions? Yeah.
So EST?
Estate of. Yeah, estate of. Yeah. So how could they have avoided that? How could they have avoided probate? How can your clients avoid probate? There's really, the easiest ways is a deed. So you can do joint tenants with right of survivorship. Does everybody know what that is? Yeah. Okay, familiar. So again, I don't do title, don't do closings, anything like that. But do you guys have in-house title or yeah?
Yes, we have your title, but they can use any
okay.
company.
So your title company, your title agent can do that. Make the deed joint tenants of right of survivorship, which just basically means if there's two owners, when one of the owner dies, his or her half goes to the surviving person. That would avoid probate. Another common way is if we look at the last example on the property appraisers that I gave you, address 13926 Southwest 161st Court. You see the owners are Karen S. Rodman, and after that it says TRS. What that means is this property is in a trust. So a trust was set up. Karen is the owner of the trust. When she passes away, it's going to go to her beneficiary, which is on there as well, Karen Rodman. So a trust is a very useful way to avoid probate. One of the main things I see where people kind of don't do the entire process correctly with a trust is they'll go to the attorney's office or maybe try to do it themselves. They'll create the trust, but they don't rename the property. They don't put the property in the name of the trust. So I could do a piece of paper that say I leave my apartment at 123 Main Street and I put it in a trust. But if I actually don't do a new deed and put the trust as the owner of the property, it's not going to avoid probate. I know I'm like flying through this, so I don't.
So let me
yeah.
Clear that out. So I can open up a trust.
Sure.
But if I have in that trust XYZ Main Street, Miami, Florida, on that trust, but on the actual tax roll, on the actual property, I don't name it that is under the trust.
The trust is worthless at that point.
Good information.
The trust is worthless. Yeah, because the deed is what controls. The deed is the main thing that controls. Yes, ma'am.
Now, under the trust, doesn't that bring up flags to the bank and then
Yeah, and
transfer of title?
Yeah, and so I don't want to get too far into trust, but that's a good question. So trust sometimes, depending on the lender, if there's if there's still a mortgage on it, they might not allow you to put it in the name of the trust. Each lender is a little bit different, but generally, if there's a mortgage, yeah, you probably can't put it into the trust. But that's so that answer your question then. Yeah, so that's you want to make sure that the deed controls. One other thing is kind of a misconception: wills do not avoid probate. So a lot of people will have a will and they'll say, I leave my 123 Main Street property to my daughter. She can't go after dad passes away. She can't go to the courthouse or anywhere and say, hey, look, my dad left me this property. I get it. Put the property in my name. The clerk, the court, the judge, whoever is going to say, no, you have to go through probate. So that's a big misconception. I get a lot of potential clients or clients that will come to me and they'll say, look, I have this deed, or excuse me, I have this will. It was done by an attorney. I should get the property. And I say, well, you will get the property, but we still have to go through the probate process.
I have that's great that you brought that up. I just had this morning a call from a friend of mine that is going through that situation right now. His mother, his grandfather, which is the father of his mother, the grandfather just passed away. And they just, went through the process of, the cemetery, funeral, and everything else. And now they find out 2 weeks later that the grandfather did not leave the house to his daughter.
Yeah.
Which was the only daughter.
Yeah.
She thought that by grounds of like I'm the only daughter, I belong, I have that property, it's mine, right?
Sure.
Well, he left a will to her cousin.
Yeah.
And he just texted me this morning. I said, look, it's so funny. I'm having an attorney for talking about this today, so I'm going to refer it to you. But they are there's a will in existence that they want to know if it's legal. Mm-hmm. They want to know if they can contest it because, they don't know how does that happen.
Right.
If he did it with conscious, what he was doing, he was an older person, et cetera, et cetera. So that can happen. So even if you have a will, can be contested.
Oh yeah, absolutely. Yeah, wills are contested. I wouldn't say all of the time. So it's kind of sad, where I get wills and I'll read them and they'll say I leave everything to my daughter Sarah. I specifically don't leave anything to my son John. And so people write like very crazy stuff like that. But yeah, you can contest a will. In my world, most of the times what I see is it's because it's an older person and maybe we're saying they didn't have capacity, they had Alzheimer's, something like that at the time. Or it wasn't done properly. A lot of like the do-it-yourself wills, if they're not executed properly, sometimes we can contest them on that. Which is a good segue into second part. So for you all, you want to make sure that you're speaking with the right person. So in this case, for example, if the realtor was speaking with the daughter and the daughter says, yeah, no, my grandfather or father, I'm sure I get the property, but it turns out she might not be getting the property. So you don't want to spend all your time working with this client just assuming that because they were the daughter or the son or whoever, closest living relative, that they're automatically going to get the property. So what you want to do, I always encourage realtors, if you're going to a probate listing, a listing presentation, and you know that someone's passed away, ask two things. Ask, did the person who passed away, did they have a will? And then ask if you can get a copy of it, if they have a copy of it. Again, at that point, you'll probably turn it over to your attorney, but you just want to know, is there a will? Are they in it, so that you kind of have an idea if you're speaking with the right person. Also, again, like I said earlier, wills are not recorded, so you want to ask if you can get a copy of it, because I've had people say, yeah, I think my dad did a will, I just can't find it. Unfortunately, if I don't have a copy of it, or if he or she can't find a copy of it, no one's going to be able to find the copy of it.
Okay. These are the 3 cases that you said could be possible, because I just had a case where the property was under the mother, the daughter, and at the end it says REM, which is remaining.
Remainder, yeah.
So,
Is that no, deeds could have a lot of different things on it. These are just 3 examples of.
you said 3 examples, and one said EN.
Yeah.
I don't know what that means.
Beneficiary.
Okay.
Yeah.
So basically, REM and
Sort of, sure. Essentially, yeah. Essentially, that just means whoever's named as the remainderman or the beneficiary is going to get the property. Yeah. Yes.
The trust, and then having a beneficiary like it is on this particular property report. The person has to be dead.
No. Most of the time, who has to be dead? The person setting it up.
The estate says.
Can you speak up so we
Roman
can all hear the
estate.
question?
So she said when setting up a trust, who has to be?
Like on this one, it says trust, and then it has this person, Karen, is the
So
beneficiary.
Karen is a daughter. It's two different people.
Uh-huh.
Karen on the top is the one creating the trust. It's her trust.
Okay.
In her trust, she's naming her daughter as the beneficiary so that when she dies, the property automatically goes to her beneficiary.
Okay, so in order to do that, the person can be alive.
You have
Set
to be
up
alive.
that
You have to
trust.
be alive.
Okay.
You have to be alive. To set up a trust, yeah, you have to be alive. Yes, sir.
Obviously, because of the nature of where they live, we have a lot of older people that in the last 10 years have took reverse mortgages.
Yeah.
And at one point, because the criteria of a loan is you have to be older than 62 or 62, some of the actual couples may have had to leave the property back to the spouse that is older. What other problems does that bring into trust, or is that a problem that is difficult to resolve, even if there is a trust?
Yeah, the mortgage will trump the trust. The mortgage would, I think you would have problems putting a reverse mortgage into a trust. I've never seen that. I don't know that it's not possible. I've just never seen it. But assuming that it is possible, if when the owners of a reverse mortgage pass away, they're going to start the foreclosure process to take back the property. So the only way that the beneficiaries would be able to keep the house is if they pay off that.
They have it in the process, so, but you still have trust. A lot of the people created the trust for that purpose.
Right. But it's not going to, if you owe money on a property, they're going to take it.
No, I understand the process, but I'm more concerned about the title and the ability of whoever's, the remaining person of the couple can actually either buy the property back or sell the property.
Like, do you mind, that's a one particular case, I wanted to just go over like.
Yeah, I'm
the
happy to chat
actual-
with you after.
But you
That's
can
fine.
save him on,
Yeah.
one-on-one, so you can actually.
Okay.
talk about it.
All right.
One of the things that I
Yeah.
would like if you can, bring back is the importance of, because I always wanted to give my agents tools so that when they go to a listing presentation, what are the things or suggestions you can give us, to let or to get into that information?
Yeah.
In that conversation with the client about probate or about anything that
Right.
has to do with,
Yeah.
especially older people.
Yeah, you're setting me up perfect. Okay, so I'll give you like the two technical things that I just from like your all's perspective how it kind of changes your process, because the truth is a property in probate either from the buyer side or from the seller side is not going to affect what you all do too much, right? It's really the attorneys. Your biggest thing is handling the client, just managing the client's expectations, which you guys have to do anyways. But I'll talk in 2 seconds about how long probate takes. That's probably the biggest concern I get, and also maybe how much it costs. But one thing you all need to know is who you're working with, how to sign the listing agreement, and how to sign the any contract that you have. So the biggest takeaway I would say that you guys should take away from this presentation is that you have, again, this is coming from the seller side, assuming that you're working with the seller. You have to work with the personal representative. And just because there's a will that says, John is the personal representative, that's not good enough. You need a document from the court that says John is the personal representative. So you really can't do anything until you have that piece of paper that says he's personal representative. But in practice, you go to someone's house or listing presentation, whatever. He's not appointed personal representative yet. Maybe his dad just died, and obviously you want to sign up this client. You need a listing agreement, right? What I always recommend to realtors is have John sign the listing agreement as the proposed personal representative. Okay? He's not yet the personal representative, but in that listing agreement, if you just write John Smith as proposed personal representative, of the estate of whoever passed away, at least you kind of like lock him in as your client and he's going to use you as the realtor. But you can't start listing the property yet. You can't start marketing the property yet because because John is not yet personal representative. Once we get in there, the attorney gets in there, does the probate, and John is appointed personal representative, now you all can start listing it. Now you can start marketing it. Now you can sign any contract. And the contract is going to be signed John Smith as personal representative. Does that make sense? There's a big distinction because, again, I think that's the biggest thing I see realtors maybe making a mistake with is they're speaking with the son. They know the son's the only child. They think he's going to inherit the property, so they get off to the races and they start marketing, start listing the property. But John doesn't have any right to sell that property yet until he's personal representative. So when you're getting a listing agreement, sign it as proposed personal representative, and then once we get that piece of paper from the court, then you can market it as personal representative. And then one last little thing in the contract, because these do take a little bit of time, I always advise realtors or whatever attorney you're working with, your title company, real estate attorney, in that paragraph 20, I don't know what it is, additional terms, just put in there subject to court approval. Because most of the sales, most of the contracts going through probate are going to have to be approved by the court, and so you don't want your seller being liable for, hey, why didn't you close in 60 days like we said? That way you just have some simple language in there that says subject to court approval.
That language you wanted to put it on the contract or
Yeah.
on the actual listing? On the contract. Subject to court approval.
Yeah, on the actual contract, yeah. On the contract, yeah. Yeah. Okay, and then so before backing up before you get the listing agreement, I think, in my opinion, when you all go to these listing presentation, just by talking a little bit about probate, asking the questions, was there a will, what's your relationship to the person who passed away, most realtors aren't asking those just very basic questions. So I think you'll kind of, once you even bring up the probate process, because I get clients all the time who they don't know what probate is. They have no clue. So you're going to find that as well. So if you just say, oh, well, probate is this process where we take your property and the court says that you can sell it, they're already thinking like, okay, this realtor stands out from the other 51,000. Yes?
How important is it? Because obviously people die, they just don't have the original will. So they have this copy.
Yeah.
Is that, if they don't have the original, is that a delay?
It's an added step. The court needs the original will. If there's not and this is like maybe too technical, but if there's not the original will, then I've got to find the two witnesses who signed it, and they have to sign like an extra affidavit. So it's like an added step. So yes, you want to keep track of the original will. All right, and so then how long? I'll wrap up on these last couple things. So how long does probate take? So I'm going to give you two examples. So the key kind of factor to determine how long it's going to take is when the person died and when you open the probate. So the first scenario is the person died, let's say, more than 2 years ago. If the person died more than 2 years ago, let's say 2015, now we're opening up the probate, it's been more than 2 years, it's going to take us, on average, again, we're in about 17 counties, so each judge, each county is a little bit different. If you open the probate after 2 years, it's going to take us about 2 to 4 weeks to get the personal representative appointed. So let's just say 1 month. From the time the client gets us everything, we file everything, we're rocking and rolling in the court case, about a month to get the personal representative appointed. Then, month 2, you guys can go ahead, list, sell the property, do whatever you need to do. You guys are ready to go. Generally, we're going to have to get the sale approved. That might take 2 weeks, more or less. So I would say if the person died over 2 years ago, it's probably going to be about a 2 to 3 month process for the probate. In theory, it should be. Now, I've got cases where we've got siblings in Israel and they don't want to sign everything, and we're trying to send like couriers to the Gaza Strip, and I mean, seriously, and it's just like, it's taking a lot longer than normal. But on average, if everything's going smooth, 2 to 3 months. Yes. Okay, yeah, last thing. So, but if it was within 2 years, so if someone died, let's say 2018, we're opening up the probate now, It's going to take, again, 1 month to get us someone appointed personal representative. And then there's a 3-month window we have to wait. So month 2, month 3, month 4, we have to wait for any creditors to come and tell us if the person who died owed them money. After that creditor period is up, then you guys can sell. So it's going to be month 5 or 6 months, more or less, if someone died recently. So either 2 to 3 months or 5 to 6 months, depending on when the person passed away. And then very, very lastly, I always get asked, how much does it cost? It really depends. In Florida, attorneys are either going to charge hourly, they're going to charge a percentage, or they're going to charge a flat fee. I generally only charge by flat fee. Most prices, again, probably on the low end are going to be around $3,500. On the higher end, probably $10,000 is probably what you're looking at for just a standard probate. So that's all I've got. If you guys have any questions, I'll stick around for a little while. I've also got cards up here. And then if you guys want to be entered for a raffle, please put a business card in here. Yeah. Sure.
Obviously, sometimes you have husbands that pass away, have a wife now passing away. They had a trust. That's something that is better to have a trust than to have a will.
For avoiding probate, yes, it's better to have a trust. Oh, and I should say, so we do, if you guys are interested, we had a couple handouts for just simple estate planning, writing wills, writing power of attorneys, living wills, healthcare surrogates. So if you're interested in that, we have some, and these packages we put together just for realtors. So happy to speak with you all about that. Thank you,
That's
Martha.
great.
Yeah.
No, that's great. Any other questions for Justin? This is a topic that is very, very important. You hear your business card over there? Oh, you got it? Perfect. Very important. Very important topic that lately, believe it or not, the reason and the main reason that I want to bring him over is because I've been having lately a lot of cases, a lot of contracts that are under either a trust, estate, or people that have been dead, and now there's only one person live, and there's an issue with, what do I do with this listing? Honestly, sometimes I know that you guys, no, not there, just put it there. One of the main questions that you guys have, and you get, you bother when I ask you papers, is because of this same situation. You're gonna have to have the papers in hand, but when the time that you get, that contract. So I'd rather have, you have go through the listing